In this webinar, we will be looking at the principles of needs, sharing and compensation, the difference between matrimonial and non-matrimonial assets and how the court deals with them, the special status of the family home, when non-matrimonial property will be invaded, how the court deals with special contributions, post-separation assets and accrual, relevant case law, and practical guidance on how to approach a case where arguments as to matrimonial and non-matrimonial property may arise. We will also touch briefly on how using nuptial agreements can protect non-matrimonial assets in divorce. We'll start by journeying back to the landmark House of Lords decision in White and White in 2000, which made achieving fairness a top priority when dividing finances on divorce. Many practitioners agree that this judgment marked the most fundamental change in family law since the 1970s. Prior to the judgment, the norm was that a claimant's spouse, usually a woman, would have his or her needs reasonably met, but that was all. There was not an arithmetic calculation for the division of the matrimonial assets. It was often the case that a wife would receive considerably less than 50% of the matrimonial assets, which was potentially discriminatory against women and failed to protect non-working mothers. White and White, the facts of which we will consider in more detail later, marked a significant change in this regard. Lord Nichols emphasised that there can no longer be gender discrimination when determining the allocation of ancillary or financial relief. He said, if in their different spheres each contributed equally to the family, then in principle it matters not which of them earned the money and built up the assets. There should be no bias in favour of the money earner and the child carer. The House of Lords also recognised that by being at home and looking after young children, a wife may forever lose the opportunity to acquire and develop her own money-earning qualifications and skills. Lord Nichols said that a family judge would always be well advised to check his tentative views against the yardstick of equality of division, and that as a general guide, equality should be departed from only if, and to the extent that, there is good reason for doing so. The need to consider and articulate reasons for departing from equality would help the parties and the court to focus on the need to ensure the absence of discrimination.